Good afternoon. Welcome to the Appellate Division First Department. This afternoon, we have some 5.5 hours of argument time requested. So please bear that in mind as I call the calendar. Remember that we have your briefs, we have the record, and we're fully familiar with the facts of your case, so keep that in mind, all right? This afternoon, I want to welcome a class of 12 law students and Professor Maria Gonzalo, and they hail from the Dominican Republic, where they study law. They are hosted by none other than our Justice Manuel Mendez. They are in an internship program through which they are introduced to the system of justice here in the United States, and you learn about the different courts and how we work. So we're very happy to have you here. And I think since you're here, it's appropriate to point out a fact that I think we're very proud of in the United States, and that is that 58 years ago today, the Honorable Thurgood Marshall was sworn in as the first Black Supreme Court Justice in the United States. So you're here on a memorable day, although it wasn't this court. All right, for the counsel and call, let's see what we have. People versus Lawrence Downey. Submitted. Martinez versus Martinez. So tell me, appellant, how much time are you seeking? Okay. 5 and 1 and 5. Yorbis is submitted. Nation Star Mortgage versus O'Connor. Submitted. Yakel versus New York City Taxi and Limousine. We have 2 appeals. Okay, I'll give you 6, 2, and 6. People versus Cameron Golphin is submitted. Law firm of Jennifer Zook versus Lemus is submitted. HSBC Bank versus Wu, submitted. Bonilla versus BPP St. Street Owner, submitted. Mila M. Five, 2, 5, and 3. Reclaim the Records versus City of New York.
Respond to request 6.
6, 2, and 6. Contreras versus Parkash.
Good afternoon, Your Honor. Jesse Young for the appellant, requesting 2 and 6.
You want 2 minutes on your main argument and 6 on rebuttal?
Yes. No, I'm sorry, 6 and 2.
Sounds more like it.
David Gorelick of Chartwell Law for respondent. I'll request 6, please. Thank you.
We'll do 5, 2, and 5. Thank you.
Thank you.
Peck versus Milbank.
Good afternoon, Robert Gorelick of Milbank for the appellant, requesting 6 and 2. Afternoon, Your Honor. Matthew Prescott, LLP for respondent, requesting
6, 2, and 6. People versus Jonathan Luna. Did you want rebuttal? 5, 1, and 5. Vasquez versus Bronx, Lebanon is submitted. Sabre Chemicals is versus Northeast Chemicals is submitted. And Not sure if I mentioned Yorbis, but Yorbis is submitted. It's number 3 on the calendar. All right? Martinez versus Martinez, please. Just a moment. Okay.
Good afternoon, Your Honors. My name is Jennifer Provost, and I represent the defendants in this matter, who are also the appellants. Your Honor, may I request a minute of rebuttal?
I gave you a minute of rebuttal.
Thank you, Your Honor.
Yeah.
So this matter,
So you argue that this motion should be denied as premature.
yes, Your Honor.
And I imagine that's because all depositions were outstanding except for the plaintiff who moved. Were those necessary for a finding here?
Yes, Your Honor. Not only the depositions of both my client and the plaintiff passenger of the moped, but also videos that were not available to us at the time that the motion was made.
Don't we have a police report that indicates that the moped driver was on the wrong side of the yellow line? And we have testimony from the moped driver that he was unlicensed?
That's correct, Your Honor.
And we have testimony from the main driver that he had, the van driver, that he had completed his turn, he looked, he saw no one, he put on his blinker. Is that not enough to reach a conclusion here?
Yes, but the conclusion that the judge reached was without articulating what was written in the police report and what was also substantiated by my client's affidavit. So the judge only considered what the plaintiff testified to. What you just articulated, Your Honor, is exactly what I thought should have been considered in the judge's decision.
Didn't you, sorry, go ahead.
That's the information that was placed in your client's affidavit.
The information in my client's affidavit was that the plaintiff was on the wrong side of the roadway, heading in the opposite direction, thereby not operating his vehicle properly. The judge in the decision ruled that plaintiff operated his vehicle with the right-of-way, and that's erroneous. He never considered what the defendant articulated in the affidavit, nor did he consider the police report.
Are you saying that the defendant raised an issue of fact?
Yes, Your Honor.
Anything else?
If there are no more questions, I can rest on my papers unless
Okay.
I get an
Thank you.
opportunity to rebut. Thank you.
Good afternoon, Your Honors. May it please the court. My name is Aparna Pujar from Napolish Kalnik, and I represent the plaintiff respondent in this case. Your Honor,
So tell me, how is this not premature on the one hand, and then you can get to the facts, but you submitted this motion, this summary judgment motion, before any other depositions were completed. Your client's was the only one that was completed. The other co-plaintiff, who was a passenger, that wasn't completed, neither the deposition of the defendant or so why is that? Why isn't that premature?
Your Honor, it's well established that you can move for summary judgment before discovery is completed. There are several...
Yes, except for when there are other witnesses that may be necessary, like the other plaintiff here.
Respectfully, Your Honor, you can, even before the other depositions are completed, you can move for summary judgment unless the defendant here shows what specific facts did they need and why did
You're
they
the
need those
movement.
facts.
You're the movement, so you have to meet your burden first. But there were I mean, it seems like a bit of sharp practice to put in your papers before other witnesses to the accident, other plaintiffs, in fact, had a chance to be deposed.
And further, usually in a negligence case, there are issues of fact, and summary judgments are rarely granted on negligence cases.
Your Honor, in this case, there is no question of fact because
So let me ask
admittedly
you
the
this.
defendant.
Sorry to interrupt you, but you say that it's okay to, obviously, and there is case law to that effect. Is it also okay then to use the deposition that was not even taken before the summary judgment motion was made, and to use that in your reply? Is there something that says that's proper as well?
Your Honor, there's nothing that says it's improper.
So that sounds like it's proper to go, to file a motion before any deposition is done, and then to use the deposition that comes in after the defendant's papers are due, but in time for your reply, and use the defendant's deposition in that reply.
Your
That
Hon-
sounds appropriate.
Your Honor, my client's deposition was completed.
If you would just answer my question, does that sound like appropriate practice?
Your Honor, if that deposition is disregarded, even then, there is no question of fact.
Counsel, I have a question for you. Just, it seems to me that there are issues of credibility, particularly since the defendant, as counsel indicated, testified, well, I should say, put in the affidavit, that the plaintiff, was on the wrong side of the road, crossed the double line, and obviously your client says something different. Would you agree when there are two different versions, credibility is at issue?
Your Honor, credibility issue is always before the jury. But in this case, there is no credibility issue because,
When there are two different versions? Because there are two different versions of how this happened.
Your Honor, even if there are two different versions, the fact remains that the defendant took an illegal U-turn. It does not matter, even if it goes to that, that is an issue of contributory negligence.
Were there any signs in that part of the road that said that a U-turn was not permitted?
Your Honor, it is a matter of law that you cannot take a sudden U-turn.
Can you answer
Well,
the
that's,
question?
but two things. According to the defendant, it was not a sudden U-turn. He stopped, he put on his signals that he was going to turn, he looked, and then he proceeded to make the U-turn. And there were no signs in the area, unless you can point to any, that says that U-turn was not allowed in that particular spot.
Your Honor, there were no signs that said that, but Your Honor, we have a witness statement which says that he did not put any signals on, and my client says he did not put any.
So then you have contradictory testimony as to what actually occurred. One, your client and your witness say that he did not put on the signs. He says he did, and he further says that his vehicle was struck after he was on the other side of the double yellow line, meaning that your client crossed over the double yellow line in an attempt to get around the defendant's vehicle and then struck it.
Your Honor, my client says that he thought he was going to double park. Defendant's vehicle was about to stop, so he tried to go around, take a left so that he can go straight. So he had a right-of way, but suddenly the defendant's vehicle decided to take a U-turn. And Your Honor, the police report that they cite to, it's not certified. It's an uncertified police report. Secondly, the police officer did not witness this accident. It is some unknown witness who witnessed this accident, and that is what is written in the police report, again, which is uncertified.
police-
So that is purely his.
Counsel, I wanted to ask you earlier when you had said that the defendant had not articulated any discovery that was actually needed. Didn't they want to introduce the video that they had gotten later? Isn't the video something that needs to be seen?
Your Honor, the video is completely immaterial because the video does not show how the accident happened. It just shows the aftermath of the accident where my client is being taken on a stretcher. The defendant is assuming, so my client, because of the accident, my clients flew and they fell. So they fell on the other side of the road. So they are assuming because they fell on the other side of the road.
Well, I don't want to know what you think anybody is assuming, but with regard to the police report, if the police cannot testify or write up a report about what they did not see, but they may about what they actually see, and what is on the report is what they saw, where the moped was after the accident, not what they saw the moped do because they weren't there to see that. That's what the report is, and that is something that we can consider because it's just they're stating what they saw.
Your Honor,
Thank you very much. At the podium, please. Thanks.
Your Honor, if there are no additional questions for me, I think I will rest on my papers.
Thank you. Thank you both. Yackel versus New York City Taxi and Limousine Commission. We have two appeals here. Just a moment, please. Okay.
Good afternoon, and may it please the court. Tom O'Connor of Fox Rothschild for the appellants Joseph Yakul and Meyer Yakul. Your Honors, this appeal concerns rules that were adopted by the Taxi and Limousine Commission to govern the Medallion Relief Program.
That's right, and done so that the city could assist financially distressed medallions owners and to sort of restructure their debt, but not meant for owners who had more than 6 or multiple, medallions.
That's
So
correct.
it seems like the contention here is around, because medallion owners can't possess an interest in more than 6 medallions, and it seems like the contention here is about the term possess an interest. So why don't you tell me what
Of
you have to
course,
say
Your
about
Honor.
that?
So the text of the rule indicates or states that as long as an applicant, meaning a medallion owner who's applying for medallion relief, possesses an interest in 6 or fewer medallions, that they're eligible for the program.
Sure, that part I said.
Yes. Both of the appellants here, it is conceded, have an interest in less than 6 or fewer medallions. That is, Meyer Yakul has an interest in 2 medallions, only 2, and Joseph Yakul has an interest in just 6.
Well, actually, it's the companies that they have the LLCs in that seem to have the interest, because the owners are not them, but it's those companies.
Yes, Your Honor. 2 points there. Of course, it is the LLCs that own the medallions. No LLC owns more than 6 medallions, to be clear. So even if one were to look at the LLC to measure whether it's eligible for the program, each of the LLCs involved certainly qualifies. Secondarily, it's been conceded in the papers below, and an issue, it has been conceded, I'll leave it at that, that the individuals are equitable owners of those medallions. So they have the ability to bring these proceedings, and in fact, it's TLC that made these applications on their behalf.
Yes, but what we're focusing on is the difference between, of course, the possess an interest in, and I think the way you would like it to be defined as own.
Own indirectly or directly. To go to Justice Frank's original decision in this case, and this is a unique case in that we have 2 very different decisions on what is essentially the same application from the same justice. So I'm referring to Justice Frank's original decision, where he pointed out exactly what the issue with TLC's approach is.
Yeah, but first of all, we should be, TLC is the commission that
Yes.
oversees this. And usually when it's agencies, we look to the agency to make that determination with what that interpretation should be. There's nothing here that defines possessing an interest, but there's nothing in that statute that uses the word owner or ownership. So,
Well, that's not exactly correct, Your Honor. There is a definition of a medallion owner, and there is a
yes,
definition
but
of an
with,
applicant.
in B1, I think it is, not in B2, where the word is not used. And since they do define owner in B1, they could have used owner in B2, but they chose not to. The word does not appear.
Right. They did it a different way, Your Honor. They said an applicant must be a medallion owner, and that the applicant then cannot possess an interest in more than 6 medallions. Now, but this issue about possessing an interest, there's no way to define interest, and this goes to the heart of the case. There's no way to define interest in a way that would give either Joseph Yakul, Meyer Yakul, or any of these LLCs an interest in Zion Yakul's medallions. And that's the only way that the Taxi and Limousine Commission was able to arrive at its determination that these petitioners were not eligible, that they attributed to them medallions that they did not own or did not possess any kind of an interest, directly or indirectly.
Counsel, if Zion owns 120 medallions, he would not be able to apply for this relief.
That's absolutely correct, Your Honor.
But his partner, his 50% partner in equity in those 6 medallions or the 2 medallions may.
Yes, Your Honor.
Doesn't that defeat the whole purpose of this program?
It does not.
Which is to assist the small medallion owners.
It does not defeat the purpose of the program, Your Honor, because both Meyer Yakul and Joseph Yakul, the applicants, are in fact small medallion owners. That is, neither of them owns more than 6. You could envision a situation where an individual who wants to get a medallion and earn a living as a taxi driver has to partner with one of the larger taxi owners and becomes a part member of their LLC. Why would we come along and say that this person is not someone who's intended to get the relief under the statute? And we have to be faithful to the language that the TLC used.
I think more to the point, we have to be faithful to the purpose behind the policy.
We have to be conscious of both, Your Honor, but there is what is not entitled to deference, to Justice's point earlier. What is not entitled to deference is an agency interpretation that is irreconcilable with the language of the underlying regulation. And that is what we have here. We have an agency that has said, we're not going to look at the interests of the applicant, that is, the individual who's applying, or even the LLC owner. Instead, what we're going to do is something very different. We're going to look through what effectively is the corporate veil and attribute interests to these folks that they don't have.
Thank you.
Good afternoon, Your Honors. Jennifer Lerner on behalf of respondents. So this case involves TLC's rational interpretation of its own eligibility rule for its medallion relief program. And I think it's beyond dispute that TLC's interpretation is entitled to deference and may not be disturbed unless it is clearly irrational.
Counsel didn't, I don't think, use that word, but he is implying that it's irrational because it doesn't allow for these 2 sons who have 2 and I think 6 medallions to be included in their father's that has 120.
And here's why it's TLC's interpretation is rational, because you have to look at who the benefit is going to. And I think Your Honor raised the issue of interest, and I actually agree with my adversary here that it's not really about the interest, it's about who is the applicant, who's getting the benefit of the program. And the benefit is going to the LLC who owns the medallion. That's why the rule provides that the applicant must be a medallion owner. Now, of course, business entities act through their people. So someone has to submit the application. But the medallion loan that is being restructured, the grant that is being used to pay off part of the loan, all of that is to the LLC. So that is why when there's a business entity, in terms of the number of interests, and this is why TLC's rule is entitled to deference, because they're familiar with how these entities are run, each having LLCs that each have 2 or 3 medallions. Now this,
So it's necessary to look at the principles in each
Exactly.
of these cases.
exactly, and that is what makes sense and is consistent with the purpose of the rule, that it's for small medallion owners.
Does it matter the percentage of ownership that any one of these principals has?
I don't think it does. I mean, I could imagine a theoretical case where if the interests were widely disparate, maybe there'd be some sort of fairness argument, but we don't have to get there here. Here, it's 50% or 51-49. I don't think that matters here, because what TLC does consistently is look at the principals who are the members of the LLC, shareholders of the corporation, to see what other interests they have. And here, the father, Zion, has interest in 120 other medallions through however many 50, 60 LLCs.
So if he was to divest himself of his interest in these particular LLCs, then these would be eligible.
Sure, if the sons owned these by themselves and had 6 or fewer medallions, they'd be eligible, without question. It's because they are partners with the father, who has a large taxi fleet, and that is not what the program was designed to help. I mean,
And so as partners, they get a benefit from the
yes,
other
it's
aspect.
the LLC that gets the benefit, the loan reduction, the grant, and that benefit necessarily flows to the members or shareholders. And just to point out, consistent with the purpose of the rule, I mean, these rules weren't created with this in mind, of like this widely disparate ownership. Okay, these rules were intended to help the owner drivers, right, who you may remember there were hunger strikes, and helping the immigrant owner drivers or the small business entities. And in that scenario, this doesn't come up, because if you have an individual, it's very simple, right? If they hold the medallion in their own name, see what else they hold. But even a small business, let's say they're partners in a business, they're both owners of whatever medallions, and it's the same. There's not this question. It's this sort of unique scenario where this large taxi fleet owner said, okay, sons, you can have an interest in these, and you have an interest in these.
And in one case, it's a 50-50 partnership. In another, I think it's a 51-49 partnership. So that's a significant.
Yeah, I mean, I think in the one where it's 51-49, there's even a stronger argument why you have to look at the father's interest, but I think it still applies when it's 50-50, because TLC is going to be consistent about it and look at all the interests and make sure that the program's benefits are going to who it was designed to help, and that is small business owners. And the key here is this is TLC's interpretation of its own rule, and it makes sense here. So even if you could look at it another way and say, oh, I'm the applicant, I submitted the application, maybe you could view it that way. As long as TLC's interpretation is rational, that is what controls here. And I think the point Justice Frank made in the decision below is that how can it be rational or make sense to have one member of the LLC be able to submit the application so that the LLC gets benefits and they're entitled to participate, but if the other one does, it didn't. It's the same LLC. And that, I would submit, is completely irrational, and why another reason that TLC's interpretation makes sense and the order below should be affirmed.
Thank you.
Thank you.
Your Honors, we I believe have had an important concession when counsel was asked about would a medallion owner be disqualified if there were different percentage ownerships within an LLC. She said, well, I'm not really sure. It may depend on the facts and circumstances. This goes to the heart of why this ad hoc rulemaking is arbitrary and capricious, right? What we have on the books is a rule which says that an applicant cannot have an interest in any more than 6 medallions. It is conceded that none of the LLCs have an interest in more than 6 medallions, and none of the individuals have an interest. That is, Joseph and Meyer have an interest in more than 6
So you're
medallions.
saying it's okay to get around the heart of the purpose of the rule the way you can get around it, rather than interpreting the rule in a way that upholds the purpose for which the rule was meant.
It's not at all what I'm saying, Your Honor. There is no construction of the words in the rule that could lead to any of the potential applicants, whether it's the LLCs or the individuals, having an interest in medallions owned by someone else. That is a fundamental principle of our, not just our corporations law and our LLC law, but that people are separate from one another, right? There is no way to interpret the word interest to say that Meyer Yakul has an interest in his father's 120 medallions.
So basically, the way that this is written, the applicant being the LLC, right?
They've argued that it should be deemed the LLC or it could be the individual, but it doesn't matter for purposes of this argument. But yes, Your Honor.
But if it says applicant must possess an interest in no more than 6 medallions.
Correct.
Right, so you're saying if it's only, if it's the LLC, then we have to look, I mean, that's what they say, we have to look at the shareholders, the individuals, and see if whether or not they own an interest in more than 6 medallions.
Right. That's their argument, Your Honor, but it would not give the LLC an interest in those medallions. That is, the fact that the LLC may have members who themselves separately own medallions through other LLCs doesn't give the LLC, which is the applicant in their view.
But isn't it the way that ownership is held in this industry of these medallions, that is done by LLCs and that have shareholders?
Of course.
But, well, then this rule, applying it the way that you suggest, my colleagues are correct. It would defeat the purpose. Then basically, everybody would qualify.
No, Your Honor, that's not correct.
Isn't there a benefit to other members of an LLC?
There may well be a benefit to, there certainly would be a benefit.
So then the idea is that the other members shouldn't get that benefit. A member who has 120 medallions shouldn't get a benefit, but there is a benefit.
Your Honor, the objection is not to the Taxi Limousine Commission deciding what it wants to do to implement a policy. The objection is that what it has done to implement what it believes are the policy objectives conflicts with the language of the rule. That is why what they've done is not entitled to deference, because there's no way to construe either the word applicant, as to which there is no issue, or interest that could result in any applicant having an interest in more than 6 medallions. And respectfully, Your Honor, that is where Justice Frank was correct. And he pointed out the fallacy in that argument the first time, that while Zion may have an interest in these medallions.
We have your
Yes.
argument.
Thank you, Your
Thank
Honor.
you very much. Thank you both. Mila M.
Your Honors, may it please the court, my name is Amanda Abata and I represent ACS. This court should reverse the family court's decision because it lacks a sound and substantial basis in the record. While the family court found that the mother hit Mila numerous times, it was error to conclude that this harm could be mitigated sufficiently to warrant returning the child home for the pendency of this proceeding. The evidence showed that the mother engaged in severe and excessive corporal punishment out of anger without.
There's no question that the mother did engage in such punishment. In these cases, aren't we also to look at whether there is a way for the child to be returned and deferred to the family court if there are procedures in place? So my question to you is, the court required the mom to refrain from corporal punishment, to comply with mental health services, to comply with anger management and parenting classes, and all ACS requirements, including weekly visits. So there should be a sound and substantial basis. Tell me why that wasn't a sound and substantial basis that the court put into place. And with regard to the mother not being completely, I'm not looking, aware is not what I mean, but of what she did and the impact of that. She did seem to indicate towards the end of her conversations with the judge that she understood what she did was wrong, although she certainly didn't say it that way.
Yes, Your Honor, and I would begin with that point specifically because as the mother concedes in her respondent's brief, that's a foundational element. Her failure to take responsibility for Mila's wounds, her claims that she didn't know that how Mila sustained those injuries, along with the incredible story she told that the father injured the child, these all collectively show her lack of accountability and the insight.
Well, that's what she said in the beginning, but I mean, what we hope is that people learn and that they change and that they improve. And I understand that, I guess, it's not a problem, it's we want these things to move along quickly, but because it's so quick, the first conversation she had where she lied was different than the last one, where she doesn't say, I know what I did and I was wrong, but she says something like, I plead the fifth, which is indicating she knew fully what she did. She just didn't want to say it out loud, but it was understanding fully. And with that understanding, she then agreed to make all of those steps. So together, those things is that.
Well, Your Honor, I would just make one more point with regards to sort of like her accountability. I would argue that even in the respondent's brief, the mother does continue to sort of minimize her actions, which sort of shows that she doesn't really have any insight into her behavior. She fails to express remorse, and this is and it doesn't seem that she's progressed past the point where we spoke about where she really hasn't taken accountability despite months of ACS services and participation in counseling. Now, with regards to her testimony that she would comply with ACS supervision and follow court orders, I don't believe that there is a sound basis in the record to support that. This court found in the matter of EE, which is a case that's really instructive here and similar, that a mother's unwillingness or inability to acknowledge her own role in the circumstances that led to a child's removal, along with the fact that she had previously engaged in similar conduct, is evidence that no mitigating factors can protect the child.
Did this mother engage in similar conduct before this particular incident?
Yeah, Your Honor, within this limited record alone, we have 4 instances of corporal punishment, and with regards to the subject incident, and we have 4 instances of corporal punishment, and 3 of them occurred within the 2 months that Mila came back from living with her grandmother to live with her mother. Within those 2 months, the mother slapped her twice, and then we have this specific subject incident where the mother then, after a cooling off period, struck her with the charging cord, reported 24 times. I would say that the sort of mother's testimony that she would comply with ACS supervision is undermined by the fact that again, she's missing that foundational element of personal accountability.
But the court imposed certain conditions on the mother.
Yes, Your Honor.
Returned the child to her and imposed certain conditions. Wouldn't those conditions be sufficient?
We're saying here it's not, Your Honor, because first of all, we have the fact that prior to this case, the mother had that indicated report of excessive corporal punishment against 2-year-old Mila, but that didn't stop her from continuing to use corporal physical punishment against the child, even though ACS intervened in that case, even though there was an order of protection filed against her on behalf of the child, and even though by her own admission, she'd engaged in some individual therapy. So we have all of that as a basis to show that despite all of these, services that could be in place, it's not supported by the record that the mother would comply with those in terms of sufficient to minimize the harm to Mila.
Thank you.
Good afternoon, Your Honors. Legal Aid Society by Daniel Abdul Malik for the subject child. May it please the court. We are co-appellants on this case, not just because the court erred in its analysis of whether or not orders could be put in place to mitigate risk of harm. But because for our client, the court at no point balanced not just those mitigating factors, but anything regarding her best interests. The court had on the record before it significant evidence that not only was the child physically harmed repeatedly, that's noted by both the caseworker, our client, and photographic evidence, but also that the respondent inflicted tremendous emotional and psychological harm on her. Now, respondent stated, both in testimony and in responding papers, that she had a reason for doing this, that she had concerns. But I think what's clear from the testimony is that these weren't about some outlandish behavior that she was trying to correct. She was worried about a potential incident that happened months prior in another state. What's clear from the record is that she was responding in anger, anger that she clearly could not control, anger that was so severe that when she woke up the next morning in a calculated effort to strike the child, not just once, not just twice, but 3 separate times, in between forcing her to go to the bathroom to look at herself crying, not for any corrective purpose, but because she was angry. She noted she was angry not just at my client, but she was angry at her own mother, she was angry at the child's father, and she took that anger out on the child. The court had the opportunity to balance a number of factors, including services that our client might need, services that the respondent might need, the severity of the injuries. The caseworker noted 6-inch marks that she observed and took photographs of. The fact that the respondent at closest admitted to slapping the child, but then noted that she might have hit her with the cord. As this court and its sister courts have held, 2 key components of whether or not in balancing the risk of harm with the risk of removal weighs in favor of a respondent is whether or not they have acknowledged and begin to correct that behavior. Here, the respondent, after speaking with counsel and after some testimony denying these actions, did eventually plead the Fifth, but had made no efforts to take accountability for how serious these injuries were, both physical and psychological. And the court, in its decision and on the record, did not even appear to weigh what time and what services could do to assist this family.
Wasn't this a little quick as far as, which I know we like, but the incident was February 21st. The services were scheduled on March 17th, and the release was March 27th. So it was pretty quick for the mother to have been able to really engage from the 17th to the 27th.
Same amount of time, if I can just answer, Your Honor. In all emergency hearings, these are quick turnarounds. The court certainly didn't take that into account in its order of what services could have been put in place, but the court also had the option to hold its own order in abeyance. If it really thought that that was the key, it could have made that consideration, allowed the mother to engage in services, and we can have a decision once we see what those services, if anything, do. Thank you.
Just before I begin, I was very deeply moved by your remarks, Justice Renwick, concerning Justice Marshall, and the honor to me, being a Dominican living here in New York, to be arguing by Providence in front of my countrymen. I'm just deeply touched, and I want to highlight that.
Thank you.
May it please the court, my name is Michael Weinstein, and I represent Ms. B, the respondent in this proceeding. I'd like to address your question first, Justice O'Neill-Levy, to my colleague. Time is actually the most crucial aspect in all of this case, because time dictates precisely not just what the court did and should have done, and the facts in this proceeding. You're absolutely right, Justice. There was very little time. We have a regime under the Family Court Act in sections 1027 and 1028. It was a 1028 proceeding here, where a parent has an opportunity to provide at any point to have their child returned to their care. Here, this happened just a few days after the Article 10 petition was filed. In fact, but for the fact that Ms. B was in jail waiting to be arraigned, this could have even been the even higher or quicker emergency hearing, a 1027 proceeding. That's why it's a 1028 here.
I mean, that,
Yes.
what you say is true, but we still have to come down to the protection of this child.
Of course.
And also, another factor is trying to repair the relationship. But if there is that limited time that you're talking about, the question is whether or not the things that were put into place were sufficient, and whether or not the mother showed sufficient insight so that, given the things that were put into place, whether or not this would protect the child. I mean, that's really what that comes down to. It's a sound and substantial basis. So if you would address that.
Of course. With respect to the services and the timing, repeatedly, the Legal Aid Society requested for therapy for Mila. And there were, I think, about 8 to 10 court appearances in this hearing. At each and every appearance, they asked, and services still were not put in place for Mila, even after Judge Wilkowski ordered that
You're
ACS...
saying this is before the fact.
Yes, this is before the
So
order was entered.
We're after the fact now.
Sure.
So that's what you should focus on.
After the fact with respect to the present, or?
No, after, I mean, you were talking about what was done before
Sure.
the incident.
Oh, no, this is after
I'm
the
sorry.
incident,
Oh,
Justice.
okay,
This
I'm
is
sorry.
during the pendency of the proceeding.
I'm sorry, okay.
So the proceedings only filed after the incident
Right.
occurs on
Okay.
the 20th of February of this year. So at every appearance, it was asked, and the services were not put in place for Mila. With respect to Miss B, she knew what ACS was asking of her through their proposed service plan, and immediately on her own went and enrolled in all of those services.
Counsel, I'd like to move to another area.
Sure.
The child particularly. Now, there was evidence in the record that the child was fearful of the mother and did not want to live with the mother, wanted to live with other relatives, correct?
That's correct, Justice. And I think we need to look at it, there are two parts to that. The first part is, what child wouldn't be fearful of their parent under any circumstance after having experienced corporal punishment like this? And this is, to be clear, we're not at all and never will minimize what happened here. But as you pointed out, Justice Renwick, it's not just...
No, I'm Kennedy.
No, I know you are, Justice Kennedy. I was looking at Justice Renwick to answer her other question, I promise. But to relate the other question, that it's not just about what happened. It's not just about the incident. It's about how do we rehabilitate the family? How do we put them together? And so to complete the answer to your question, Justice Kennedy, it's not just the incident, and it's in best interest, when you look at best interest, and we know from the Court of Appeals, from this bench's decisions, it's there is no way to quite define it. You have to look at every factor. And when you look at the relationship that Ms. Buford testified to that she and her daughter had prior to this incident, which was completely distinct from anything that had happened before, where Ms. B had allowed her daughter, Mila, to live in North Carolina so that when her mother offered that, so that she could put herself in a better position to care for her, to prepare for the second job that she had. It was, in fact, the maternal grandmother who prevented Mila from coming back to New York sooner. It was never a permanent plan. For months at a time, Miss B would visit Mila down in North Carolina.
Okay, so now you
Yes,
are
Justice.
talking about before.
No, I know. I was just to complete the question for Justice Kennedy in terms of best interest, that best interest looks to everything.
I agree. So can we now move on to, it just seems to me, your client's lack of responsibility. You know, when she was shown the photographs, did not know how they resulted. Certainly, there was an alleged incident with the father where he allegedly struck her with, I believe it was a hanger,
Yes.
but yet did not call the police.
So, if I may answer, I know my time is up, but I don't have anything from the record in terms of why the police were not called back in September of 2024 when the hanger incident happened. However, there is a nuance in terms
Allegedly,
of...
you know, and allegedly, those fresh marks came from the incident that happened a year ago.
So actually, the quote, if you look precisely at the record, the timeline is crucial here. When the CPS goes to visit Miss B in her home, he mentions that she had marks. Miss B did not know that from the incident that happened in February 20th that there were any marks on Mila. And so she posits that if they found marks, maybe it was that, but she never outright denies that it could have been her and follows up with, maybe it was me. And in terms of being able to take accountability, we have to reconcile the very real fact that there was a criminal proceeding at the time. And as much as Ms. B probably would have wanted to take full accountability, and sort of does at the end, as was pointed out here, in describing that I know not the precise words, but that she deeply regrets what happened and that everything in the petition didn't happen as it's alleged, but that she's not a terrible person. She just couldn't, and that's why sorry, I was utilized, I can't find the right verb here. She asserted her Fifth Amendment privilege against self-incrimination at the time. But in the decision that Judge Wilkowski wrote, she follows the law completely in saying she takes a negative inference, which you can do with the Fifth Amendment assertion in civil proceedings. And in all of that, put together an order that accounted for everything that this judge with years of experience with the family court system believed would protect Mila and her interests, including her best interests. Thank you, Justices.
Thank you.
Your Honor, I just want to make a couple points with regards to, I want to begin first by saying, with regards to the mother's testimony under oath, it's worth talking about the fact that she said that those fresh lash marks were the result of the encounter with the father. Then she said she didn't know how Mila sustained her injuries. Then she denied hitting Mila with an object, and all this is before she pled the Fifth. So I just want to sort of state that to sort of...
Aren't you making the point that she made those admissions and then she pled the Fifth, which means that those admissions were separate from what she was pleading the Fifth. And it was not as if she just said them without any context. The judge was asking her questions, she answered a question, she answered a question, she answered a different question. And that's when she pled the Fifth, and it was that question that made it obvious that what she was pleading the Fifth to was that she did do the things that were said. So, I mean, it's okay, but if we're going to be really realistic here and start talking about what happened, what could have happened better, we need to, be direct about what she was pleading the Fifth to. No, she didn't take full responsibility in the perfect way of saying, I did this, I'm so sorry, I shouldn't have done it, I know I shouldn't have done it. And perhaps, it just wasn't enough, what she said. But she did plead the Fifth, not to the other things, but to the things she didn't say.
Your Honor, I would say then, in response to you, that regardless of all of that, there's still our argument that there's no sound and substantial basis in the record to support the finding that could be
That's
mitigated.
what I said when I said it still may not be enough.
Yes, Your Honor, and as we discussed before, it's because there was that prior indicated case which ACS did investigate. There was an order of protection. The mothers participated in therapy, and yet all of that wasn't enough to stop her from continuing to engage in this corporal punishment, because the truth is she has an anger problem that seems to be displayed in the record. She's repeatedly displayed several instances of...
And so that may be the better thing to focus on, that this woman who has tremendous emotional issues or whatever has an anger problem, and even though she says she pled the Fifth, which may well be saying that she's sorry, it still doesn't seem to be enough.
You're right, Your Honor.
Thank you.
Thank you.
Thank you all. Reclaim the Records versus City of New York.
Good afternoon, and may it please the court. Chloe Moon on behalf of the city and the city clerk's office. Supreme Court made two errors here, either of which warrants reversal. First, it made no mention of the domestic relations law's comprehensive statutory scheme, and so its order to disclose all marriage records that are at least 50 years old circumvents the legislature's intent in creating that scheme. Second, Supreme Court recognized the serious privacy interests at stake, but failed to acknowledge that those interests weigh just as heavily for those who have been married for more than 50 years. Turning first to 87.2a, the state statute exception, Supreme Court's order circumvented that carefully prescribed process for obtaining these records. It requires the payment of a fee, and it requires a showing of a proper or judicial purpose. I'd point this court to Nyclu versus NYPD, the Court of Appeals case from 2018, where it laid out the statutory provisions that expressly operate to protect records like these, where there's third-party interests, privacy interests at stake, and says explicitly that nothing in FOIL should override that statutory intent.
So what about the 5 denied data fields? Why do the privacy concerns regarding those fields, why should they apply to that section that's over 50 years as they do to the section up to 50 years?
Yes, Your Honor. It's our position that it is the obligation to safeguard all of these records, and just because we released certain categories of information for the newer records doesn't mean that our obligation to safeguard the privacy interest of those who are married over than 50 years disappears. We also, sorry about that. We also want to be very clear that we have never disclosed records for over 50 years old, and that's important because that distinguishes it from the Nyclu NYPD case from this court in 2010. It's not the exact same categories of information, it's a very distinct category of information. And I'd also point this court to HEPS, the Third Department case, that's particularly important here. And in that case, the Third Department said that an agency that has provided some records in the past is not stopped from increasing its safeguard in the face of a newly comprehended threat. And that's what happened here. I point the court to R70, where we specifically said that there were risks of identity theft. We were echoing HEPS in that initial denial. And so we were really contemplating that that was a controlling decision and that that's what we were concerned about with these records.
And are older adults particularly more vulnerable to these kinds of threats?
Absolutely, Your Honor. That's an overriding concern for us, is that this particular population, those people who have been married for over 50 years, they didn't get married in the age of the internet. They didn't have any expectation that these records would be released.
I don't even know if the people in the last 50 years were under the impression that the internet would be releasing all of their personal information, including their address and everything else.
Absolutely, Your Honor.
Anyway, back to
Yes.
your point.
Yes, and I think importantly off of that is HEPS made very clear that there's a difference between electronic compilation and searchable form, which is what petitioners want here, and somebody who has to go through the statutory mechanisms and pay a fee and get a single record. This is what's being contemplated with this widespread disclosure is something very different than what the statute anticipates, and also what the privacy interest that we believe it's our obligation to safeguard requires. Unless this court has any further questions, I'll come back on rebuttal.
You'll reserve, or you'll on rebuttal, we'll hear from you.
Good afternoon, Your Honor.
Just a moment, please.
Of course.
Thank you. Okay.
Good afternoon, Your Honors. May it please the court. There's a real issue with what I just heard today. I looked at the city clerk's office website before I walked in the door here today, and I'm going to quote what it says. It says, a marriage record older than 50 years old from today.
Sorry, but you put your head down and not into the microphone.
My apologies, Your Honor. A marriage record older than 50 years from today's date is considered a historic record and is available to the general public, period, on their website today. So the idea that the city is now taking the position here before Your Honors that this is somehow sacrosanct data is belied by their behavior. I want to make real clear what we're actually arguing about in this appeal, because I think the clarity shows the strength of our position. At issue in this appeal, first of all of the marriage data from 1908 to 1949 is publicly available, all of it. You can go onto a city's website, 2 clicks, it's free. You can get the affidavits, you can get the records, it's all right there. So what is at issue in this appeal is from 1950 to 1973. It's those marriage records. And I think that's important because that's just a much more limited version of it. And there's no showing in this record why a record from, say, 1950 is necessarily different from 1970. And I think it's...
Counsel, when you say that all of the data from 1908 to 1949 is publicly available, you mean all of the data that you have requested, including the affidavits?
Yes, yeah, definitely. It's right there.
All of it?
Yes. No restriction. No fee, no nothing. And it's right, I mean, it's just right there. So...
And may I just change the subject a little bit?
course.
What is it that Reclaim the Records would be using all of this information for?
Sure. Reclaim the Records, as the Court of Appeals has recently acknowledged, is a genealogist organization that publishes this information for free and makes it available for everyone. That has been ruled by the Court of Appeals to be a public...
I understand you're looking at the case from 2025.
I am,
The
and I think that,
recent. I am
that
aware
is
of
a
it.
very important case for the analysis that we are conducting today, because it is dead on point. It talks about identity theft, and here's the thing about identity theft here. They have a burden. The Reclaim the Records Court of Appeals case says very specifically that the DOH has not met its burden in showing that this concern relates to a specific and particularized privacy interest. You will find nowhere in this record an affidavit from somebody saying identity theft. You will find nothing in this record tying this data to the
Well, people
sector.
don't usually know when their identity is stolen. They don't usually know where it comes from, but it's something out there. And if this is out there, it could be just as easily from this as something else.
I mean, it's not in the record, Your Honor. There's not an affidavit from anybody. There's
Because
not.
it's almost impossible to pinpoint after
Well,
it's
but this is one of the issues that the Court of Appeals recently had with how the state
aware of it.
and DOH dealt with it, because they said they did not meet their burden by producing evidence. That's what it says. Exactly as here, they produced no evidence. And that's a problem because the FOIL statute creates a burden on the state. And when the state doesn't do it, if we did nothing, we should prevail in this case. However, I think we did substantially more than that. The other thing that I think is very important about the new Court of Appeals case is how it talks about the FDNY and New York Times case, because that's obviously the case for the undifferentiated privacy entrance and the balancing test that happens. The Court of Appeals very specifically talks about the interest that we have in having free data and the various different uses for it versus the most core issues of someone dying and making a record, right? They walk back New York Times by saying, you really need to have something that is very substantive. And just because New York Times exists and creates the balancing test, I think that it shows that the types of documents that New York Times was designed to protect are very different than these kind of things. I mean, marriage records used to be slapped on church walls. I mean, this is not a type of record.
For the members of the church who didn't have any internet.
For sure, but there, again, no showing.
And no copy machines there to make, no phones to take pictures of what was on the wall.
Acknowledge.
Why isn't the information that they have already disclosed sufficient for you?
Well, it's the issue of the area between the 1950, right, and 1973. And they are acknowledging it's public data, right? They say it. Their website says this is a historic record, right? I mean, that's what it says. Free to all members of the public, sitting right there. It is not available to the public, absent some various steps. The issue with the fee, I think, is important. This was not raised till the appeal, okay? It is waived.
The attorney's fees?
No, not the attorney's fees, the fee for the statutory construction.
Okay.
And so it wasn't in the initial appeal, it wasn't in the initial briefing, like we saw it for the first time there. I will also say for the fee, that's for an official record, right? That's for like one that's embossed that you can go and then use in court documents. That's not what we're talking about here. So the idea that we somehow didn't do the fee correctly, one, it's new, two, it's a different record. Very briefly, and I see my red light, and I do very much appreciate it. With respect to the Heps case, which unfortunately I got to argue, the issue there was the records before the 50 years, right? They in the third department and the state, the older records weren't even an issue. I just think that we really need to focus on what the city of New York is saying. They are saying these are public records. And if they are public records, they need to be released. Thank you.
Thank you.
Just quickly on the public records part, that comes directly from the domestic relations law. I think it only shows that there is a comprehensive statutory scheme here. The fee itself also comes from the domestic relations law. So just because we say that it's a public record doesn't take it out of the scope of the domestic relations law and the requirement to pay a fee and to show a judicial improper.
Can somebody go on the website and get those records from 1908 to 1949?
I'm not sure about that, Your Honor, but I know that they cannot, without pursuing this domestic relations law statutory scheme, get it from the city clerk's office. So I'm not sure about those 1908 records, but I know at least for the period that we're talking about, for people who have been married prior to 1974, that they have to go through this process. I'd also quickly like to talk about the Court of Appeals case, which I know, Justice Mendez, you're on the panel for. I have a few distinctions that I'd like to offer. First, in that case, the public interest identified by the court, I think they mattered. The court said that the disclosure would reduce a backlog, that disclosure would reduce fraud. Here we have the opposite situation. We have fraud would be increased by disclosure. There are higher privacy interests at stake here because those we're dealing with death records. Here we're dealing with marriage records for people who are still alive. So their privacy interests in those records are higher, and the identity theft risks are higher for this population.
They say, I want you to get back to that.
Okay,
but
sorry.
The case also said that it required, because it said it was simply stating the proper purpose was not sufficient, that it needed to expressly state legislative intent. Requires clear, what's that clear legislative intent here?
Yes,
To establish and preserve confidentiality.
Yes, I think the intent here is shown from the statutory scheme because there's a requirement of a showing for a proper and judicial purpose. I will quickly say that in that case as well, it was interpreting an administrative regulation, not a state statute. There's no dispute here that this is a state statute. We also have in that case that the petitioners were not seeking the exact records that the statute protected in that case. So there was a certified record that they weren't seeking, and that's exactly what the state statute or that administrative regulation protected in that case. Here, petitioners are requesting all records, and so that is directly included in the domestic relations law statute that we believe is protecting these records from disclosure. Thank you.
Thank you both. Contreras versus Parkash.
Ready? Good
No.
afternoon. I'm sorry.
Okay, thank you.
Thank you, Your Honor. Jesse Young for the appellant. May it please the court. There's no dispute in this case that defendants never offered any evidence as to when the stairs in question were last cleaned or inspected.
So is it your position that the burden wasn't shifted, or that it was, or what did they have to do since no cleaning or inspection records were shown?
Yes, it's my position that regardless of my opposition papers, they never met their prima facie burden. And there's a long line of decisions from this court stating exactly that. In fact, they couldn't even name the supposed porter who was supposed to be responsible for cleaning the stairs in this building. They said, I'm sorry, go ahead.
The court indicated that your client's testimony satisfied their burden of establishing lack of constructive notice. So focus on that. Why?
Sure, there's other cases.
Was that incorrect? I think that's what you're saying.
Yes, Your Honor, I believe that's incorrect. And There have been other cases decided by this court that dealt with that very issue, which I cite in my brief. The idea that a plaintiff's failure to see a defect, whether that's liquid on the steps or whether that's a crack in the sidewalk, immediately before the accident is not sufficient to show that the condition was not open and obvious. I think that what that goes to is some contributory negligence, perhaps, which is an issue at trial.
What if the testimony of the plaintiff is conflicting, that he says he sees, one time he says he sees it in one place, and then he says, no, he saw it in another place?
Yeah, respectfully, I don't see any inconsistency in his testimony. He testified that the day before the accident, he saw a liquid condition on the landing going down from the 5th to the 4th floor.
The landing in between, you mean?
The landing.
Before the 3 steps.
Yes, yes. He testified that he saw this condition. He talked about the size of it, said it was about 4 inches wide, and it was clear yellowish color. Now, the next day.
But he slipped on the steps, not the landing.
Well, correct, Your Honor, and there is a video of this accident, which I'm sure you're aware. And so that's correct. He does slip on the middle step with his left foot. The step before he slipped was on the landing. So I think this raises a question of fact. Clearly, if you take one step into liquid, and then with your next step, you slip on marble stairs, and he testifies
what he said before and what he said after, or what he said he saw the day before and the following day were not inconsistent. That's what you're saying.
That's correct, Your Honor. And he clearly testifies that it was the same condition. The only possible difference in his testimony is he says that he saw the same area on the landing, and he also saw some wetness on the step. Now, you know, it's quite conceivable that somebody tracked a little bit of liquid from the landing to the step, or he did that. But, and again, there's really just one page of questioning.
What are we to make of, I mean, which is seen in the video, of other folks also traversing through that area of the stairs without any incident?
Yes, Your Honor. I mean, again, we don't know from the video whether or not those 3 people that are seen in the video were aware of the condition and were walking around it, whether they saw it as they were going down from the top and they just simply walked around it, or they, through happenstance, didn't step in the condition, or they stepped in the condition and it didn't cause them to slip. You know, clearly the—
Now, counsel?
Do you want to comment on the gap in the video before we?
Yeah, I would like to comment on that. So there's no affidavit from anyone with knowledge of the production of this video as to why it's only showing these 3 short clips. And again, I don't think it's sufficient, and it was their burden to present some sort of foundation as to why it only shows these clips.
I would like to go back to the porter.
Yes.
Was there any evidence in the record as to when he cleaned, you know, the area and when the building superintendent went back to check his work?
No, there is absolutely no evidence, and that's quite clear by looking at the transcript. They don't even know who the porter is. They say, we don't know what his name was, we're not sure if he was working, so there's a complete lack of any evidence or testimony as to what the cleaning procedures were, if there were any cleaning or inspection procedures.
And no cleaning records, right?
No cleaning records whatsoever. That is clear and not disputed at all in this case.
Justice Chan, did you have a question?
Yes, just going back to the video, isn't that motion activated? So there won't be any filming of anything unless somebody comes into the range of the camera?
Well, there's no actual evidence of that beyond what the attorney argues in his papers. That may be the case, but on their submission, they did not provide any affidavit from anyone with knowledge stating that. So it's argued in their papers, but there's really no evidence in the record of that.
Thank you.
Thank you.
Good afternoon. May it please the court. David Gorelick of Chartwell Law for respondent, defendant, Fed Parcash. While our arguments and the breadth of those arguments are contained in the brief, I do want to address some of the points that appellant made in his argument. First is the argument that there aren't any records pertaining to the last inspection of the staircase. That's disputed. That's not undisputed, as appellant argued. There is deposition testimony.
What records? Deposition testimony doesn't count. Inspection records mean, you know, there were actual records that were kept with regard to cleaning and inspection schedules. Is there that in this case?
There is no dispute with respect to records. There is a dispute with respect to evidence, and that evidence is testimony.
Okay, so what you're saying is there are no records of cleaning and there are no records of inspection.
That appear in the record. I'm not aware of any, no.
Okay.
That being said, that analysis about whether or not there are records that exist only comes after there's a showing of a condition that's visible or apparent for a sufficient amount of time for the defendant to remedy that condition.
So that plaintiff has said that there was a liquid on the landing the day before. And then plaintiff says that he saw the same liquid and he slipped. He doesn't say that he saw it before he slipped, but he said he slipped and then he saw that the liquid was there on the landing, and so he's saying it was there for the time, presumably from the day before when he saw it till that day, till the time when he slipped.
So that's really the crux of the appellant's argument, right? Is they want us to speculate based upon the plaintiff's deposition testimony that he saw this condition on the landing the day before, where he didn't know if it was clear or if it was yellow, he didn't know the shape of it, that it's conceivable that it was tracked to the step in question. But if we were to reverse the lower court's decision based upon that conception or that speculation, then this case would go to a jury, and then the jury would have to determine.
Well, what part are you saying he speculated about? Because he said he saw it there before. He says, I saw it there after I slipped, and you have, that doesn't sound, that's what he's saying he saw. So where's the speculation? I'm not, obviously he doesn't know, but that's what he says. And it's your burden in the first place to be able to say, we can show that we cleaned it an hour before he slipped, or we cleaned it that morning of the accident. So it couldn't have been what he said the day before. Where are your cleaning records or inspection records to be able to shift the burden? Because that's how the case law operates in this realm.
Right, so I understand. The superintendent testified that the staircase was cleaned on a daily basis in the morning, okay? And if it wasn't himself, it would be the porter, and he would inspect the porter's work, and he's always found it to be sufficient.
Except that's what he says, but he can't say, and I know for a fact that the porter cleaned it that day. The porter, who we don't know who the porter is because he's unidentified. Nobody knows if the porter did, in fact, clean it that day, which is why records are good, and he doesn't know when he inspected it. He hasn't given a time or anything with regard to inspection. So how does the burden shift when there's nothing there?
Well, respectfully, I believe that the defendant, respondent, met its burden, its prima facie burden, through establishing that there was no condition on the step at the time of the accident. Well, because the plaintiff himself testified that he never saw any liquid on the step before the accident. He only saw the condition on the step after he dropped an open bottle of tequila, Patron. So, you know, there is no evidence in the record at all.
He slipped before the bottle dropped, in the photograph at least, and he said that when he slipped, he saw the same liquid in the same place from the day before.
As Justice Guzman noted in her decision in order, the video actually shows the plaintiff overstepping the step, and his left foot, the heel of his left foot, actually struck the outer portion.
I guess that's to be determined because we've all seen We've all seen the video. All I can say is he stepped on the landing, and then I think it's the second step that he slips from.
Can you address the gaps in the video? I know that there is a contention that it's a motion generated video, that only when motion is detected, but gaps in the video alone would be enough to deny summary judgment.
So in this case, as is commonplace, it's my understanding that the surveillance video itself is likely either sound generated or motion generated, as are a number of surveillance.
Do you have an affidavit in the record as to that?
I don't, Your Honor. In fact, the appellant makes this argument for the first time on appeal. Okay, so this argument was never presented before. There's been no evidence that the video was edited or doctored in any way. There's been no suggestion to the contrary. It's not in the record. Okay.
Anything further?
No, that being said, we do.
Your red light is on, so if you have something that you really must tell us that you haven't already.
No, in conclusion, I thank Your Honors for your time.
Thank you.
Thank you, Your Honors. If there are no further questions or issues that
You rest on your brief.
I rest on my brief, yes.
Thank you.
Very much.
Thank you both.
Thank you.
Peck versus Milbank. Just one moment, please.
Good afternoon, Your Honors. Robert Hora of Milbank LLP for defendants appellants Milbank LLP and Georgiana Slade. The decision of the motion court denying defendants' motion to dismiss the Judiciary Act 487 claim should be reversed and the claim should be dismissed. The crux of this case is that the plaintiffs, and in particular plaintiff Ian Peck, is upset that his stepmother, as preliminary executor of his father's estate, sued him to collect on $3 million of defaulted notes that represented a loan from his father.
So we know the facts of the case.
Sure.
But if you'd get to the issue of the judiciary law claims and tell us on what grounds do you move to dismiss the issues?
Yes, and so really need to bucket these items in the claim into a few different categories. So number one, the plaintiffs are alleging that the very filing and commencement and prosecution of these notes cases was a quote-unquote deceit on the court. And of course, Judiciary Act 487 prohibits intentional egregious deceits on the court. However, this is not what Judiciary Act 487 is intended to address, because the reason that plaintiffs say that this case was a deceit is because they have a different interpretation of Norman Peck's estate plan.
Of the note provision?
Of a provision in the revocable trust that addresses loan obligations, correct.
So I just want to ask, this was before this court before, and this provision, I think, was said to have an issue of fact or something that didn't indicate that it was clear. Does there have to be certain clarity before you can say that it's denied, dismissal is denied under the judiciary law?
So to address that ruling, it is correct. This court in the underlying proceeding held that there was an issue of fact. There had been, prior to that, summary judgment granted. The key for this Judiciary Act claim is that no court has ever found for the plaintiffs on their interpretation. So all this is a garden variety dispute over the meaning of provisions in a revocable trust, not unlike a contract dispute, because fundamentally these are contracts.
I guess what I'm saying is, can there be cognizable acts of deception where even this court has said there are issues of fact? It would seem to me that it would have to be a clear issue of deception. So, I mean, So there is, the court has already ruled that there were issues of fact on that very question of the interpretation of this
Absolutely.
note.
I was not appreciating your question, but absolutely, right. And the sort of seminal case, Amalfitano, from the New York Court of Appeals, where there was a Judiciary Act 47 claim that was allowed to proceed and that features in the plaintiff's briefing, there had been a judgment and a trial finding that this case was wholly meritless because there were false facts brought before the court about the plaintiff's interest in a partnership that was central to that dispute. So this is a very different case than Amalfitano. We've got no ruling ever upholding the plaintiff's interpretation. There are, so that's really the crux.
One issue.
That's one issue, yeah. So another bucket would be testimony. So there's a few different types of testimony. There's an affidavit that the plaintiffs complain about that where my client Ms. Slade gave her factual recitation of the drafting history of this trust, as well as her recitation of a conversation with the plaintiff's counsel. There's also deposition testimony where my client merely says, look, I didn't recall knowing when Norman was alive, that's the decedent, that my father had investments with Norman. The simple points I would make there are, one, under New York law, there's an absolute immunity for witness testimony in civil cases to prevent exactly what's going on here. One party simply not liking the testimony, disagreeing with the testimony, and bringing an abusive 487 claim. So that's one point. Number two, I would focus the court on injury and proximate cause. The affidavit that is complained about was submitted in the notes cases in relation to a motion to transfer that the plaintiffs brought. That's a discretionary motion. They wanted to transfer the case from Supreme Court to surrogates court. It was transferred. There was nothing wrong with bringing the notes cases in Supreme Court. The case was transferred. This affidavit had absolutely no impact on the matter one way or another. And in terms of the deposition testimony, again, the witness immunity applies, but all we have is basically the plaintiffs disagreeing with my client's recollection of what she recalls knowing. This kind of stuff happens every day in litigation, right? Witnesses have recollections, and maybe there's a document where, you know, the other side might say, well, didn't you, I mean, it looks like maybe you knew this. Happens all the time. If this kind of thing can be converted into a 487 claim, there would be a flood of litigation anytime an attorney testifies.
Just with respect to the deposition, that deposition occurred prior to the commencement of the note cases, right?
There's two depositions at issue. One deposition was in the probate proceeding, and that's what's called a 1404 deposition, where they can depose the attorney draftsperson of the will. And my client, Ms. Slade, represented the decedent and had drafted the will. And she was asked if she knew during that drafting process that her father had investments in certain real estate with the decedent. She says, I didn't recall knowing. There's also a huge injury and proximate cause issue there because those investments have nothing to do with the notes that are the crux of the plaintiff's complaint.
And the second deposition, she was already out. She was no longer representing the estate, then the firm was no longer
That's
representing
correct.
the estate
Yeah.
at that time.
And in fact, our firm did not bring these notes cases. They were brought by Farrell Fritz.
Thank you.
Thank you.
Thank you, Your Honor. The trial court correctly found here that the plaintiffs stated a claim under Judiciary Law 487. The standard on this appeal is whether the complaint was sufficiently alleged. And the fact here is the trial court was absolutely right that it was.
Whether the complaint under Judiciary Law 487 was properly played.
It was properly alleged. That's right, Your Honor. Now, I want to respond.
So I guess I have the same question for you that I asked before. The question is whether or not the attorney is guilty of any deceit or collusion or consents to any deceit or collusion. Which one of these allegations that you make these claims to
Yeah, Your Honor, it's the committing deceit inclusion. It's not the consenting to part. Although I don't want to limit the case. I mean, what happened here, what's alleged, what separates this case from the kind of situation that my colleague is suggesting is
The Amalfitano.
yeah, is that there's the pleading alleges that Georgiana Slade knew exactly what Norman's testamentary intent was. She said that she put together the offset provision, and the facts alleged are that the offset provision was meant to resolve the issue of these outstanding notes, and that Norman Peck did not want litigation when he died. He wanted the notes to be offset against his son Ian's inheritance.
What about the fact that that was going to take effect in the context of the trust, and the trust could not occur until the will was probated?
So, Your Honor, it's very simple. So first of all, I've cited law that shows that this trust should be interpreted as part of the will anyway. But also, it was an unappealed finding of the surrogate's court that the trust was a codicil of the will. But beyond that, it would be ridiculous to hold that merely because of a delay, where it was a pour-over trust, that the will was going to pour into this trust. The intention was that the trust would govern the disposition of these notes. So the idea that there's a brief period, that before that happens, that then the executor of the state could do something different from what the decedent wanted in his trust, to me it's against the law, and it's against common sense. In any case, it's something that wouldn't be grounds for dismissal on a motion to dismiss. Obviously, there are issues of fact. Now,
So you're saying if an attorney thinks one thing, and I have to go back to, again,
Yes.
our case law, because I think there are two cases here that say
Yeah.
there's an issue in fact, and it's unclear what that means. If an attorney thinks one thing and has a good faith basis for that, and then in their analysis changes that view, they can be prosecuted under 487?
No, Your Honor, those are not the facts of this case. And I'm so glad you asked this question, because it's very clear. The way this is alleged is not that there's a mere dispute about what it means. What it alleges is that there are 3 instances that show the fact that Miss Slade knew and understood what Norman's intent was. And she put it in her time records. She said that in her own attorney time records that were written, I think, the same day or the day after they drafted this trust amendment, she said that she knew that the purpose of it was for the notes to be netted against the inheritance of Ian Peck, okay? Then, in the probate application, when she filed, she didn't disclose this claim as a cause of action. I know that there's some arguments about whether she needed to, but these are issues of fact for trial, okay? And that indicated that she knew at that time there were no causes. The notes were not supposed to be sued on. They were supposed to be offset pursuant to the trust. Third was the call she had with my client's counsel, Gideon Rothschild, where she said to him that under Norman's estate plan, the notes were to be essentially forgiven as an offset. He didn't say that she said they were to be forgiven, but they were to be credited. Okay, so those are 3 facts showing what she knew. And so what happened subsequently is she then went and violated Norman's intent, and that is what this case is about. It's not a case of well, there's a disagreement. There's evidence that's been alleged.
I'm not saying a disagreement. I'm saying she herself would have changed her mind, which is a little bit different than what you said, but I understand your point.
The argument, Your Honor, is that we have a base, okay? We know what she knew, and then for reasons that could be because of her conflicts of interest, it wouldn't even matter whether there were conflicts. She went against Norman's estate plan. That's what we've alleged. And on this motion to dismiss, there is no way that the court could dismiss this claim because, as you've noted, and Justice Kennedy was on this panel, the court previously found that there were issues of fact whether the filing of those note actions violated the estate plan. So I would submit it's impossible to dismiss the claim at this stage. However, it is possible to prove that it did violate the estate plan, and we submit that we will be able to do so.
Counsel, can you address his argument that the affidavit did not approximately cause any harm to your clients, particularly since they requested the transfer, which they did obtain. Can you address that argument?
I'd be happy to. The Amalfitano case that, that my colleague cited is also cited in our portion of the brief responding to the damages issue. And what it says there, well, first of all, under 487, a false or fraudulent act doesn't have to be successful even, okay? It just has to be done, okay? And what the court said in Amalfitano is the mere fact that a party is dragging out proceedings and causing you to have to defend yourself in court is by itself harm. In that case, the court found that attorney's fees from a long litigation that resulted from false statements constituted damages. And so pardon me, I think I've answered your question. Any other questions? If not,
I think not.
I'll stand on the brief. Thank you so much, Your Honor.
Thank you. Just very briefly on proximate cause and injury in Amalfitano, it is true that a 487 plaintiff doesn't have to prove a successful deceit, but they do have to show injury. And in Amalfitano, the injury was the very fact of having to defend this lawsuit itself. The affidavit and the motion to transfer, that's a very different thing because that was a choice that the plaintiff made to not be in Supreme Court when the case was perfectly appropriate to be in Supreme Court. So the affidavit didn't cause any legal fees on the part of the plaintiff. I would also make the point that the very fact that we're having a dispute right now in this court over the impact of this core provision in the trust, I would say is just proof that this is not an appropriate 487 claim because Bill Bird's from the Court of Appeals is very, very clear that ordinary disputes over legal interpretations and litigation positions are not a subject of the statute. Thank you.
Thank you. Thank you both. People versus Jonathan Luna.
Good afternoon. May it please the court. Legal Aid Society by Everett Hopkins for Mr. Jonathan Luna. Your Honors, this court should reduce Mr. Luna's sentence in light of the fact that it is his first conviction. Additionally, he's completed several programs and training programs while incarcerated, which show that he's been rehabilitated and able to lead a lawful and productive life upon his release.
Why doesn't the waiver bar his excessive sentence claim?
Because it was executed as sentencing, which was 23 days after he had already pled guilty, and the court's colloquy at that time was insufficient. With regards to the waiver discussion that they had at plea, I just want to be clear that that in no way was an oral waiver. The court, first of all, abandoned its colloquy when it found that there was an error in the written waiver, and then it never discussed any distinction between his rights with regards to his rights forfeited at plea, automatically forfeited because of his plea, and the rights that he was going to voluntarily waive. Had the court intended to...
I could be wrong, but hadn't the court gone over that already and then was at the point where it saw that the written waiver had someone else's name on it?
It was getting close to that point, but the court never asked a couple of other questions, ensuring that he understood the nature and consequence of that oral waiver. It just abandoned the colloquy. Now, had the court intended to accept that waiver at the time of the plea as an oral waiver, it would have said so, and it wouldn't have, redone the colloquy at sentencing. So the question really is whether a waiver executed at sentencing 23 days after a plea is valid.
Does it matter that the attorney at the time of the sentence said, we already went over all of that, we can just do it from this point?
It's a factor, yes, but it's not the factor. That it's the court's burden and the court's duty, not burden, to ensure that a defendant understands the nature and consequences of the right that he's giving up.
Counsel, what type of sentence was this defendant facing on the top charge here?
The top charge was a B felony, so it would be 25 years.
25 years. And he pled guilty and he negotiated down and he only received 12?
Yes, about
So
half.
that's approximately 13 years less than what he would have gotten had he gone to trial and been convicted.
Possibly, yes. And he's also facing 13 years of post-release supervision, which is just 2 years under the max, which is 15 years post-release supervision. So just with regard to the waiver, Your Honor, the court at sentencing, just to address the colloquy at sentencing, it was clearly insufficient, which is the most egregious part here, because not only does the court wait to discuss the waiver with him to ensure that he understands it, but then it doesn't attach that waiver to the rights that he had forfeited automatically 23 days ago and distinguish those rights that he's now waiving before.
Now, looking again at the excessiveness of the sentence, let's say that we agree with you that the appeal waiver is not valid, and now we're looking at whether or not this sentence is excessive. Do we take into consideration what was stated in the probation report, wherein he, in essence, did not accept responsibility for his actions? And do we also consider the victim impact statement that the mother gave at sentencing?
You can consider those factors, Your Honors, but just again, his attorney did make it clear that he was standing by his plea of guilty and that he was admitting his guilt fully. But also you can consider these ordinary mitigating factors, such as the fact that he has no record, the fact that he's facing half of the max right now with no record, the fact that he has had an unstable upbringing where he was placed into foster care because his mother had a drug problem. And
Were these items that was considered by the sentencing court and by the people when they made the offer of 12 years, instead of saying, no, you face 25, we want you to do a little more than 12?
I'll presume that they did consider those things, but again,
So if that was already considered, why should this court also consider that when he already got a reduction because of those mitigating factors?
because the Court of Appeals has said time and time again, and People v. Brisman, People v. Ba, that the court can consider ordinary mitigating factors regardless of whether it's a plea bargain for or whether those factors existed at the time of sentencing.
So your client has done a lot while he's in prison, but I didn't see sex offender treatment.
He's done about 12 or maybe more than 12 programs right now and trainings, but in terms of the sex offender treatment, I don't think he's completed it yet. My understanding is that he has started it, but he hasn't completed it yet.
So all in all, your client was given the waiver colloquy twice, and I believe the colloquy was in line with Thomas' case.
Well, I don't think it was twice, Your Honors, because it wasn't a complete colloquy. And I think that it would be really difficult to attach one part of the colloquy to the second part of the colloquy, especially after 23 days have passed by. So, I would say that the colloquy is really at sentencing, and that's when the court ensures that that it does pass Thomas, right? That there's a knowing, voluntarily intelligent waiver, because that's when the court acts and then actually accepts the waiver as such. So that's when the waiver really takes place. There was a brief discussion during a plea, but again, the court abandoned that colloquy. Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. Andrew Chung on behalf of the people. I'd like to begin by just talking about the appeal waiver briefly. It seems that my colleague's primary point here is that, according to them, the appeal waiver was invalidated by the fact that it was executed at sentencing as opposed to at the plea, but that's not the case. All that happened here was that they delayed the execution of the written waiver just to fix a minor typographic error on the document, which was basically that the wrong defense attorney's name was listed there. And as Your Honors pointed out earlier, the court actually engaged in a pretty thorough oral colloquy with the defendant and defense counsel present at the plea proceeding itself. The court actually, used the explicit phrase separate and distinct when explained that the appeal waiver was different from the trial rights normally forfeited upon a plea of guilty. And the court even went so far as to explain the limited appellate claims that would survive the waiver of appeal.
And did defense counsel agree to do the plea waiver at sentencing that needed to be done? did the defense counsel specifically agree to put it over to sentencing?
Yes, Your Honor. The defense counsel at the plea proceeding made no objection to them postponing it to the sentencing. I believe the defense counsel actually agreed with the judge by saying, "You're right, Your Honor. I didn't see that in the body of the written waiver."
It was 20 days afterwards, though. That's a significant amount of time
Yes, Your Honor.
after the initial plea.
I believe, yes, it was 23 days afterwards. I believe that is not exactly atypical in cases such as this where we're dealing with pleas and sentencings that happen on different days. But nonetheless, I think...
No, the plea and the sentencing, that was an atypical amount of time for that, but for a waiver to continue after the plea.
Well, Your Honor, I think the key issue here is that all the parties agreed to postpone the execution of the written waiver until sentencing. So whether or not it was a long amount of time in between those two dates, I think because all the parties here agreed that they were going to do that, it doesn't invalidate the waiver of appeal.
So you're saying that it's proper for the court to have advise him of his waiver of his right to appeal the first time, adjourn for sentencing, and at sentencing then go over the written waiver and also advise him again of his right to appeal?
Yes, Your Honor, that is definitely proper. Actually, as Your Honors may know, in 2022 or 2023 in People versus Coleman, this court actually upheld a defendant's appeal waiver, even though the defendant himself had not even signed the written document at all, and only his defense attorney had signed it. A written document can be helpful in establishing the validity of a waiver of appeal, but it's by any means, it's not strictly necessary. It's very good practice, though, to have one.
We have the record where he answers the questions and the court advises him of the rights he's waiving.
Yes, Your Honor.
And his consenting to waive those rights.
Yes, Your Honor. We definitely have a record of that in the plea proceeding. The fact that the appeal waiver was a condition of his negotiated plea was mentioned throughout the proceedings. And as Your Honor mentioned, the judge actually explained to the defendant that he was choosing to waive his right to appeal in exchange for the plea, and the defendant confirmed his understanding of that factor. Yes.
Now, as to the reduction in sentence that the defendant seeks, he's pointing to mitigating circumstances. Were these mitigating circumstances considered at the time that the plea was made?
Yes, Your Honor.
The offer was made?
Yes, Your Honor. The mitigating circumstances mentioned by my colleague were all considered by the sentencing court below. I believe they were extensively detailed in both the pre-sentence report and in the defendant's April 2023 letter to the court. And all those factors, including his completion of programming while incarcerated, were mentioned and acknowledged, or at least understood by the plea court and by the sentencing court.
And is this one of the reasons why he was offered 12 years as opposed to?
Yes, Your Honor. Presumably that would be why he was offered 12 years, which is on the lower half of the applicable sentencing range. And if Your Honors have no further questions, we would rest on our papers and ask that you affirm.
Thank you.
Just briefly, Your Honors. There's a focus on what the parties did and whether they consented as to this waiver being done at sentencing. And I just want to ensure that this court understands that the duty is on the court to ensure that a defendant understands the nature of the rights. So it's not something that an attorney or even the court can just waive and pass on to sentencing. There has to be some type of manifestation on the record, which is People v. Calvi, Court of Appeals case, that the court understands that the defendant at the time can appreciate the nature and consequences of the waiver. And again, Your Honors, with regards to the excessive sentence claim, although those factors were in existence at the time of the sentencing, this court can still consider them. Thank you.
Thank you. Thank you both. Mm-hmm.